In general, the European Commission tries to be helpful. However, persons who are disgruntled or aggrieved should generally try to exhaust or have recourse to the remedies which are already available to them. In the first instance, most public sector bodies will willingly accord a debriefing session. There are information entitlements, either directly under the directives themselves or, for example, under the Freedom of Information Acts, even though one has to qualify that very slightly because of perhaps delays inherent under those acts. There may be other remedies under national law, for example, under the access regulations, that is to say the European Community's access to information on the environment regulations. Those regulations accord a very wide meaning to the term environment. And there may be other entitlements as well. So in general, one should endeavour to satisfy or exhaust the remedies which are available at national level. If it is the case that there is then a stark choice between what may be expensive and perhaps slow litigation, although judicial review is generally fast, it may be appropriate to have recourse to the European Commission. However, the European Commission officials tend to be very pressed, they have a heavy burden, and they will increasingly apply the principle of subsidiarity. Where something can be dealt with at national level, it ought to be so dealt with, rather than troubling the Commission officials in the first instance. However, there are circumstances where a well-crafted submission to the European Commission may well yield results. I think the important thing with either a pre-qualification questionnaire or indeed with even a number of the other notices intended for publication in the official journal or in tender documentation is that the project be planned, that there isn't an undue ad hoc approach to generating a notice. It's also important that stakeholders within the project are involved within an organisation, so that, for example, the finance department may know what the IT department has in mind, or that there will be full coordination between the various elements which will comprise the relevant inputs from a public sector or indeed other awarding body. It's also important that there will be an understanding of what bidders will be in a position to present, so that what may turn out to be slightly unreasonable requests or impractical requests don't unnecessarily find their way into the system. In summary, it's important to plan procurement at the outset. In general, an SME is always wise to have recourse to the debriefing facility or other information entitlement which may be available vis-à-vis an awarding authority. Unduly hasty recourse to the courts is always something to be guarded against unless the circumstances are of the utmost urgency and magnitude. Indeed, in general, the courts will be more sympathetic will tend to be more sympathetic if there has been an attempt to use the existing facilities which are in place, including any recourse to debriefing or other information. The European Court of Justice has made it clear on a number of occasions that the detailed European Union public procurement rules are themselves effectively a subset of competition law. They have made it clear that two fundamental principles underpin all aspects of the public procurement directives and indeed of public procurement law more generally. Those are transparency and equality. In other words, awarding bodies must be open and they must be fair in their according equality of treatment to different bidders. Of course, there can be account taken of different circumstances, but there must not be invidious or unfair discrimination, and the bodies are themselves entitled to circumstances where justice is seen to be done so far as possible. Proportionality itself is something which is part of our own administrative law, and in Ireland the principle of proportionality and indeed the principles of a basic fairness of procedures are guaranteed also by our constitution, and hence it cannot be ousted either by the terms of any particular public law administrative requirement, and statutes are construed or interpreted in a way which will ensure that those principles are respected. It's also worth noting that under the principles of judicial review as handed down by the European Court of Justice, and which are intended to protect those principles of equality and transparency, the standard which an applicant has to meet in order to be granted redress is generally considered to be slightly lower. That is to say, less of a hill to climb for an SME where there is an issue under EC public procurement law as applied in Ireland than would be the case under the generality of judicial review in Ireland, where there is quite a high hill to climb. And that is clear from particularly the judgment of the European Court of Justice and of the Supreme Court in the litigation between SIAC or SIAC and Mayo County Council.